This is not just her relationships, and I think all of that is stated in the pre-sentence investigation report.
Due to injury to a child, a first-degree felony. I've received the pre-sentence report, as well as I've visited with the attorneys, and for the record, we have also Ms. Randy King here, who is the assistant district attorney that handled the termination and CPS kind of portion of this case with regard to the children. I've received, has everyone had an opportunity to review the pre-sentence report?
Yes, Your Honor.
Are there any additions or corrections to that report?
No additions or corrections.
Ms. Smolfino?
Judge, I would just ask the court take judicial knowledge of the conversation we have had with the court and the understanding that this has been discussed at length upstairs. Ms. King has also provided me a tremendous amount of guidance, which I thank her and appreciate everything she's done with her wealth of knowledge and experience in guiding me through this case. I know the facts themselves are extremely egregious. It's difficult for all of us to look at. I would recommend Ms. Schultz is getting this opportunity because she has availed herself of certain things and tried to make progress. The children, her rights have been terminated, which she voluntarily gave them up, and they have been relocated.
Let's pause right here. This is bigger than it sounds. The court is dealing with a first-degree felony involving a child, and yet we're already hearing about leniency. That only happens when something behind the scenes shifts the narrative. But here's the real question. Has she actually earned this second chance? Or is the court taking a risk it might regret?
Out of state to a stable environment where they will not have to testify against their mother, which was something that we took into a great deal of consideration. I would ask the court consider special needs safety in lieu of ISF cognitive. I think it is a more lengthy and a more appropriate term in custody as either an upfront type of sanction, but more so to give her the tools to be successful on this probation, because as the court is aware, and I'm sure Mr. Samuel has advised Ms. Schultz, and I do not mean this statement to seem punitive, but if Ms. Schultz is back before you, violation of this probation because of this opportunity she's been given, the amount of time that the state will be asking for will be overwhelming.
Thank you, Ms. Smolfino.
Now this is the defense strategy: no prior record, no major drug history, and signs of progress. Classic mitigation. They're not denying the severity. They're reframing the defendant as someone worth saving. But in cases involving children, that argument doesn't always land. So the tension builds. Will the judge focus on rehabilitation or the irreversible damage already done?
Anything, Mr. Samuel?
Yes, Your Honor. I understand the position of the state. However, I have to look at things from the position of the individual. The pre-sentence investigation report shows that she has no prior criminal history. It shows that she has no drug problem. There is a question about the alcohol. However, we believe that that can be done without the need of the inpatient treatment of the ISF. We believe that she's finally working. That is one of the most important things that she has to deal with in what she's gone through. She's experienced the trauma relationships, and I think all of that is stated in the pre-sentence investigation report. But what you do not hear is the experience with the other partners of the children. She has carried this burden. She has tried to do the best that she could at the time. She's educated, she has a degree, but she has not been able to find employment. She's finally working, and we just ask that this be held in advance for at least 90 days. That will show if there's an alcohol problem. That will show if there are other problems that she's experienced. She has been to a mental health specialist for counseling, and she will get with them again. And we believe that if that is a part of the order for mental health compliance and condition, she can do that. But let her prove to the court that this is not just her as it is today. this is a result of everything that she's experienced in her life at this point. I just pray that the court will have mercy on her and give her that opportunity.
Well, Ms. Schultz, you're getting mercy today. You're getting mercy from these ladies as well as myself, if I go along with this agreement. Mr. Samuel has worked very hard and is very passionate about helping you, and I appreciate that. My position on this is based on